This year, I had the pleasure of sitting down with Mr. Hasit Seth Sir, independent counsel, mediator, and arbitrator, who is also the ambassador to the novel Cross Moot 2023. It was indeed a pleasure to go over with Sir on the novel Moot and all its elements. So, good afternoon, Hasit Sir. Thank you so much for sitting down with SCC and agreeing to be interviewed about the Cross Moot. Thank you so much. So without further ado, we'll dive straight into the questions. I'd like to first ask you to introduce yourself to our audience.
Yeah, sure. So my name is Hasit Seth. I am practicing counsel, arbitrator and mediator. I am based out of Mumbai. I have an American background and an Indian practice. I mean, I've been 25 years in practice. So that's my background as an introduction. So I'm basically a disputes practice person with different roles.
Great. Thank you so much, sir. With that out of the way, I'd like to now ask you about the thing that we're all here for today, the Cross Moot, for which that you've been appointed as the ambassador by the team. So, sir, would you like to tell us a little bit about the Cross Moot and what it entails?
Yeah, so the Cross Moot is a skill-based exercise. It is focused only on the cross-examination component of a trial or an arbitration as it comes, but particularly for international arbitration. So Cross has practiced in international arbitration. So that's its main focus. So the idea is to have a competition focused only on one particular skill, because you have trial competitions, you have arbitration competitions, but most of it is focused on appellate advocacy, or even in international arbitration on the final arguments. Or opening arguments sometimes, and there are negotiation competitions and all kind of that stuff. But this is a very, very sharply focused competition only on cross-examination skills, and nothing else. So that's its uniqueness that it's focused on. So it started in 2001. So every year it's been happening. So first two rounds were virtual because of pandemic and other reasons. 2023 round, which will run from November 4 to November 8, it's going to be an in-person physical presence round, and it will happen in Paris. It will be the competition is hosted by a number of institutions. Chief among them are Sciences Po, which is a leading university law school which teaches arbitration. Its LLM program in international arbitration is very famous. Then there is the New York University, NYU, the National University of Singapore, Queen Mary University, London. So these are the major institutions supporting it on the academic side. But the main, on the international arbitration side, the support comes from ICC, which is the International Chambers of Commerce's Court of Arbitration. So that's these are the main institutions, and there is other institutions like Compass, Lexicon, and DChamps Law Firm, which is offices internationally. So all of these organizations are involved. They are all essentially wanting university students. So nobody with a license, practicing license is allowed. So it's only for students, university teams, and the focus is only on cross-examination. The case I'll talk about later, but that's the USP of this competition, that it's powered by an academic set of universities, an arbitral institution like ICC, which is easily one of the most well-known arbitrations since many years, decades. So that's the background of the competition.
Yes, sir. Thank you so much, sir, for telling us who the organizers are, a little bit about the Cross Moot, its inception, who can participate, and what it entails, basically. Thank you so much. So now I'd like to ask you more specifically about the Moot proposition. So as we know, the 2021 proposition dealt with the renewable energy plant, and the 2022 proposition was also very interesting. Now I read that the 2023 proposition or the mock case is about the aviation industry. Would you care to share a few details of that?
Yes, so what I would recommend is that even if you are just checking out the Moot, on its website crossmoot.com, anybody can download the 2023 problem, and also if you're interested in 2022 and 2021 problems, it's a single PDF file, but the zip file as it downloads also includes two spreadsheets, and the case's content and the subject matter is really focused on an aviation dispute, an airport runway expansion, airport project. and also it involves a current issue, of ESG, which is environment focused kind of like governance focused problem. The always CrossMoot for last this will be the third edition. They've always focused on something current in terms of the case that is created, but that's like the overall major theme. The main thing about the case is its structure, because you're not going to use the facts merely to include in a memorandum, etc., because there is no memorandum here to be submitted, unlike Wismoot court or Jessup or any of those competitions. Here it's directly cross examination, so whatever is there in the record, that is going to be used in your cross examination. The interesting part is, and I'll talk about a format little, you also have to be witness. So you need to know the problem. Fact witness you can be, you'll also need to know the problem very well, of it, and it without going into much details, it is a very interesting problem and factually heavy. There are around 27-28 exhibits on either side. There are damage calculations, there is a quantum expert involved, and the interesting part is that when each team will also have to examine a real life quantum expert, a financial expert. So that's going to be the most interesting part. So I think it's a great platform to see or experience how an international arbitration actually works, because rarely do you see it in this kind of circumstances. So you take up other competitions and don't name them, but it's essentially like a problem and a legal analysis and arguments. A memorandum is written. Very little tests you of what you would do actually in an international arbitration. So this is a great platform to actually see, and the participants with a real life expert is something that you would do in your first international arbitration also.
Indeed, sir. So on that note, I also wanted to ask you about the motivation for this competition, because this is, as you said, a very, very focused and specific competition with a particular skill that it picks up. And it's not institutional in the sense that it is organized by world leading arbitrators as a collective for the students themselves. So would you want to tell us a bit about the motivation for this competition?
It's backed up by a very top team. You have top professors who really want this competition to succeed as an increase and grow as a skill-based exercise. So what happens is, and you would see relate to your own experience in law school also, is that you learn evidence law, right? Evidence Act 1972, but there is really very little opportunity to apply it, because all of our law school learning happens through appellate cases, reported cases. How many people would have read even a trial court judgment during the whole law school experience? Almost no opportunity unless you go out, and some are available online, but obviously not everything is available online like a database, easily. But some district court judgments are reported, they are there in the SSC database also, but not everything, because our focus generally, we are a common law system, is based on precedents, and precedents are in appellate court cases, because those are to be followed by lower courts, or subordinate courts. So that's the motivation, that these people wanted a competition which both for civil law countries which does not have a cross-examination tradition in the way it is there in the common law world, and also in common law where the law school structure, really, except for competitions and clinics, really there is no academic training for cross-examination. So through this, the idea was to promote it. And you have top names like, Professor Mr Hasit, one of the top international arbitration practitioners, Yasmani Fatemi of GBS. They are all there in the main organizing committee, and many experts from ICC and other the Compass Lexicon, everybody's involved. So the idea is to essentially have a platform to learn and practice skills of cross.
Perfect, sir. We do understand that and appreciate it very well. So I also wanted to ask you on the point of, just for the benefit of the students, if you want to tell us a bit more about the details of the competition, in the sense that where it will be located.
Yes.
What about the registration and everything like that?
Yes, so the registration date, is 15th of September is the last date, to register online. So the website is crossmoot.com, so CROSSMOOT.com, no dash or space or any character, just crossmoot.com. And you just have to register at this point, and get like your university's approval, etc. For your team to be sent there. And the mechanics of it is that it's going to be held in Paris. The venue will be announced a little later, but it's in-person physical, so travel is involved, in it. And it's structured as like a number of rounds, initially. So there are no national rounds, unlike say Frankfurt Investment Moot Court or like Jessup or this thing. So there are no national or regional rounds, etc. Directly everybody competes in Paris. And then there are final 3 rounds where you have quarterfinals, semi-finals and finals, which would be on the elimination kind of basis that teams would drop out, as such. But the initial rounds are where you will meet a number of teams and cross-examine, and be cross-examined, because the other side will cross-examine one of your witnesses. So that's how the format would work,
Wonderful, sir. Thank you so much. Sir, I also wanted to ask you, since you are a leading arbitrator in India itself, about if you had any tips or recommendations for these students who will be participating, because this is something that's very new for them.
Yes, the competition is also relatively new, 3rd edition. But I can tell you that, personally, if you ask me, I'm not a big fan of moot courts. I participated in 1 or 2 in law schools. Neither I have liked this thing that, it almost becomes a one-upmanship competition and a very subjective kind of grading and all that. But I think the Cross Moot really caught my attention, and it's very different in the sense that it's all skill-based. And your skills are not demonstrated over one argument or some fancy case you have cited, or you had access to a better library so you did better, etc. It's not, it has none of those elements of traditional moot courts, advantages, disadvantages, or pluses or minuses. It's pure skill, pure mastery of the facts and your cross-examination strategy, that how would you cross-examine a witness, and it's all extempore. There is very little to prepare. You could prepare, in a moot court, okay, these are potentially 3-4 arguments. That one is usually on jurisdiction, one is on, some legal issue, etc. So 2-3 points are there. This moot court has 2-3 points to argue. But which is a great competition. I have been an arbitrator for this moot court and all that. It's a great competition by itself. Nothing wrong with it. But why Cross Moot is different is this reason, that you really have to prepare it by repeatedly, trying out, practicing, cross-examining witnesses. And just imagine, if you come out of a law school having, practiced cross, even for the reason that you're going to compete in this competition for many, many times, and you have tested, your strategies over a number of witnesses who may not react to the same thing in the same way. You may have, you may try, say, other moot court competition, you try it with a practice rounds with your teachers or, seniors, etc. There's almost predictable responses, because there are only so many ways in which, that legal question or jurisdictional question can. But here, each question can be answered uniquely by each person. So, very great preparation in the process of itself preparing for the exam. And I encourage you to download the problem. There is no sign up required, no fee required, nothing to download. The main competition has a €300 fee to put in the application and be compete in the round. But there is no fee to download the case and read it and just see for yourself that what complexity it raises. I think traditionally cross-examination is considered the apogee of a lawyer skill. Our legal training is still, training to be a disputes lawyer. We don't train M&A lawyers from first year, that transactional lawyer.
Coming to the format of the competition specifically, could you please enlighten us a bit about the competition details?
Yes, so the competition is a very interesting format and something which you may not see in. Typically, what happens is a witness on the civil side, like after the amendments to CPC in 1999-2000, most of the direct evidence is done by filing an affidavit in lieu of chief examination. So that's by affidavit. They are known as witness statements in England, for example, under the CPR rules. International arbitration also very common to file witness statements. But in criminal law, of course, direct examination is oral. In this competition, the direct examination is oral. So first, the team, from which the witness is coming will do a 5 minutes direct examination. Then the opposing team will do a 30-minute cross examination. Then 7 minutes for redirect examination, and then again 7 minutes for recross. So that witness is going to be tested, heavily. And the same thing would then you would also get an opportunity to cross-examine a real-life quantum expert. So this is about the fact witness. So if you are the witness, which is you are the team which is introducing the witness, so the cross-examination will be done by opponents. Direct and redirect would be done by you. Cross and recross would be done by opponents. And then you would next witnesses, because you would be having another witness, would be a real life, like a quantum expert. So those are like the which is like the competition format. I mean, how the nitty-gritty of how the competition is structured.
Thanks a lot. So that's quite a unique format. Now I know we've talked about it before, but I want to get more into the mock case, which deals with the building of an airport, if I'm not wrong, and the aviation industry, and there's charges of corruption involved. So could you tell us a bit more about the moot proposition?
Yes. So the moot is run under the ICC rules of arbitration. Then you have actual real life. Let me talk about what's in the packet, the zip file that you download. It's I think about 248 pages long. I mean, very longish kind of packet. Unlike you would see where moot problems are 3-4 pages, but it's pretty much on the with similarity wise with this problem, where we get real evidence, correspondence and all that. So there is correspondence about invocation of the arbitration, so that's correspondence with the ICC secretariat. You have correspondence about appointment of arbitrators, as you would have in real life. You also have procedural order 1, which usually set up the case management, the whole arbitration management with a timetable. So there is a PO1. There are also PO2, PO3s are there. Then there are claimants 27 exhibits are there, which is essentially correspondence and documents and reports. I mean, the concession agreement is there, which is a build, operate, transport, like a PPP project of an airport project. And then similarly for respondent side, so both sides also have their skeleton arguments put in. So these skeleton arguments is a very international arbitration specific thing, where just like the English court practice or something with the international arbitration has adapted, is that you could choose, instead of filing detailed pleadings, that will go ahead with the skeleton arguments and evidence. I mean, so those are there. They are like expertly drafted and reviewed and like really looked into. So really great material to study from. A respondent has 27 exhibits, I mean R1 to R27. Then there are spreadsheets with damages models where this thing, and those are very critical to prepare for cross-examination. So the 248 pages and the spreadsheets, I mean, so it's a real life case file which like a typical arbitrator would have in front of them, with documents submitted by the claimant and the respondents, and also the expert reports and all the evidence, I mean. So that's the structure of the case file.
Great. So that all sounds very intriguing. I don't have any further questions for you, sir, since I think we've exhaustively covered almost everything about this moot, and I'm sure many students from at least Indian law schools would be eager to participate in this novel innovation of a moot court competition. So thank you so much for speaking with us.
Thank you so much. Thank you to EBC. Thank you to Denton's Legal, which provided the office space to record this interview, and their partner Abhishek Sharma in particular. So thank you very much.
Thank you, sir.